So let's look at the questions for November 2022, starting with the general comments from the examiner. So you can see here, not looking so good. General performance not very satisfactory. So not one of the good years, but you can say Section A most failed to correctly address all the relevant issues, so did not do well in Section A. In Section B, need to be more analytical. So section B, they're expected to identify all relevant issues in each question, even though those issues may not be explicitly stated. So that is true. Is you look at past exam questions, that even the ones we have looked at so far, quite a number of them, the questions explicitly state exactly which of the sub-issues you need to discuss. So when you see that in an exam, you should be quite happy because you just follow those difficult to do wrong. But sometimes, it's not as explicit. Sometimes you say what personal actions can be taken or what claims can you make on behalf of the company. Then, of course, you need a deeper understanding or a better understanding in order to select the right issue. So just be prepared. I think rightly so, the examiner can ask all types of questions. Some can be more explicitly stated, but some may require your deeper understanding in order to identify them. So just be aware it's possible to get those two types. But if you encounter exam questions where the examiner explicitly stated already, then I think that's helping you. So make sure you follow them. Okay, so high marks can only be achieved if candidates correctly identify most relevant issues that relate to each question in section B, and they need to have analytical skills. So we've seen this in all the past examiners' comments before, so no need to discuss them again. So let's start with question number 6. We have a company called March Hair Limited, an advertising agency specializing in online and digital marketing. Has 3 directors, Eleanor, Jake, Bessie. So the company has 1 class of shares. Each director holds 15% of share capital, remaining 15 held by Carol Limited. So you can see 3 directors all hold shares, but they're not the majority holding. The remaining shares held by another company, Carol Limited, 55%. So one of the company's largest clients, Floral Brands Limited, it pays a large annual fee for the company to manage its online presence, which covers targeted advertising campaigns during the year. Now, 2 of the directors, Eleanor and Jake, met with the head of Florals to discuss the upcoming renewal of the contract. Eleanor stated that due to increased costs, the company is introducing a new fee structure. As a result, the annual fee will increase by 10%, and targeted advertising campaigns will be additional costs over and above the annual fee. So Jake, the other director who went with Eleanor, he was surprised by this statement because as far as he's aware, contract is already very profitable. So the change of fee structure has never been discussed by the board of directors. However, he remained silent. After the meeting, Eleanor calls the head of marketing privately, offers to take over the contract via her own consultancy business for a much lower fee. Floral does not renew its contract with March Hair, instead transfers business to Eleanor's consultancy. So you can see some possible wrongdoing there, some possible directors' breach of duties. Okay. So at the next board meeting, Bessie informs the board Carol is planning to sell his shares in March Hair to Red Queen Limited. So the major shareholder plans to sell the shares to another company. The directors of the company are unhappy about this possible change of control, so they subscribe for new shares that they agree the company should issue. The result of the issue is that each director now holds 25% of the company shares, and Carol's shareholding is reduced basically from 55% to 25%. So here, I think hopefully after reading this paragraph, you can already see a possible problem, maybe with the allotment of shares and maybe a disagreement on whether Carol can transfer the shares. So Carol's board has learned of these events, is unhappy as they remember that when the company was incorporated, its articles provided its members should have preemption rights. So is it should Carol be allowed to have some additional shares as well? I think that's a dispute. So advise Carol whether any of the directors have breached their duties. So you can see some key questions here already. So examiner's comments clearly need to discuss about the breach of duties, but the candidates were required to identify the specific duties of the directors engaged by the facts of scenario in question. So again, candidates should not simply list out all of the directors' duties without analyzing the specific situation. So some candidates made this mistake in the paper we saw before in June 2023, and they made the same mistake in November 2022. Good news is it seems they did not make the same mistake in subsequent papers, so that's good. So let's look at the breach of duty. We've seen this case before. Is the duty not to usurp corporate opportunities. So when you are dealing with a company as a director of the company, you should think of the interest of the company and not divert those opportunities for your own company. So application here, Eleanor is a director of the company, owes a duty to act in the interest of the company. She represented the company in the dealing of floral brands, so she would not have been aware of the opportunity and be able to gain the contract if not for her position in the company. So applying Cooks and Deeks, this would amount to a breach of duty not to divert or not to usurp business opportunities from the company. So what about the allotment of shares? Any possible breach of duty? So Section 140, you can see is a company is not allowed to allot shares unless under Section 141 has the company given their approval in advance by resolution. So we've covered this section earlier already. We're talking about a situation where you need the shareholders to pass an ordinary resolution allowing the directors to allot new shares. So in terms of court case, in this case, directors have a fiduciary duty to exercise their powers for proper purpose. So it would be a breach as a substantial purpose was unconnected with management or other proper consideration. So you can see is directors have many powers. They're granted many powers to run and manage a company. So that's why the fiduciary duty is to exercise those powers for proper purpose. If it turns out that's not the case, it will be a breach of that duty. So application. Here, the three directors cannot allot shares to themselves unless they have shareholders' approval in advance. So an ordinary resolution is required. The three directors together only owns 45% of the shares. So they do not have enough votes to pass a resolution if it is not agreed by Carol. So clearly Carol would not agree to allotting more shares only to Eleanor, Jake, and Bessie. So clearly they have committed an offense, and then you can see possible fine and also possible imprisonment. Now, even if approval was obtained, you need to consider if the directors have exercised the power to allot the shares for proper purpose. So applying the court case as the substantial purpose of issuing the shares was solely to dilute the voting power of Carol Limited and not connected with management or other proper consideration, it's likely they have also breached their duty as well. So you can see it's because they did not agree with Carol Limited, but Carol Limited holds 55% majority of the shares. What they have done resulted in Carol Limited shareholding being reduced from 55% to 25%. So if that was the purpose, then clearly they exercised their power as a director not for proper purpose. So unless the three directors can show they had reason to believe that Red Queen Limited would not be favorable to the company, would act against the interests of the company, then clearly they had breached their duty. Okay, so question 7 is very similar to those insolvent liquidation questions we saw before with the limited assets, with the different charges and the payments. So that's why I would suggest we can skip this question. You can see all these are very similar. So don't worry, you will all have these slides. So feel free to go through them yourself at your own time. But since you can see they're all repeating the very similar things, so that's why I thought better to skip to the next question. Okay, so question 8. Suits and Boots Limited is a private company incorporated in Hong Kong, selling uniforms and workwear. It's been trading successfully for around 10 years. It adopted the model articles with the following additional clause. So the company shall not enter into any contract over 2 years in length without the prior approval of the members. So, if you have read up to here, hopefully you may see it is possible it's talking about an internal regulation on the powers of the directors. So normally the board of directors would have the power to enter into a contract on behalf of the company. This clause is saying if the length of the contract is over 2 years, they need to ask the members for permission. Okay? So the board is keen to reduce its manufacturing costs to expand its market share. The board decided to set up a wholly owned subsidiary company in the mainland called Star Limited to manufacture its products. The board also agreed that one of the directors, Cam, should travel to the mainland to investigate the new opportunities. So Lily, the company secretary of the company, arranges Cam's trip. She booked first-class flights and arranged for a private car and a driver to be at his disposal for the duration of the trip. While in mainland, Cam meets with Seal, the chief executive of Premium Distribution Limited. They agree that Premium will manage the worldwide distribution of the company's products, and Cam signed a 5-year contract with Premium on behalf of the company. So when Cam returns to Hong Kong, the other board members have concern. They are unhappy with the contract, which they consider very expensive and of poor value. They state they did not agree to fund first-class flights or private car for him. They also reported that there had been a number of claims against Star because a chemical used in its manufacturing process had caused severe allergic reaction in many customers. So you can see they are unhappy about quite a number of things here. So advise the board whether the company is legally bound by the contract with Premium. So remember, they signed this contract. Well, Cam signed this contract with them. Is the company bound by it? Number 2, is the company bound for the payment of the first-class flights in a private car? And also whether any liability for the claims, if any, against Star. So this is an example where I think the examiner very explicit on what needs to be discussed in answer to the question, so it should be quite helpful. For the topics, they should be from Learning Outcomes 2 and 1. And the comments, basically, most candidates demonstrated knowledge and understanding of the concepts of apparent authority, while some also define the concept of statutory indoor management rule. So that's good. But only a few made appropriate references to relevant cases for the issue. This is about the authority to enter into a contract by the company secretary. So this is not one of those common topics, so it's understandable why some of the candidates may not be that familiar. They're also expected to discuss about the separate legal entity principle and lifting the corporate veil. So this is quite key principles for company law. So I would expect many candidates now should be very familiar with them. However, many candidates explain the concept of statutory derivative action, which was irrelevant to this question. So hopefully for those who are watching this online workshop, they will understand the comments of the examiner. Why statutory derivative action would not be relevant? Because here, I don't think there's any misconduct by any of the director to the point where a member need to make a claim to the court on behalf of the company. So I think that's why the examiner is saying that would not be relevant here. Okay, so first of all, authority of a director. So you can see here, because Cam signed some contract by himself individually, so that's why we need to first discuss whether he has authority or not. So the case of Haley Hutchison talks about implied actual authority. Okay, so in terms of authority, you can have express actual authority. So for example, if they appointed Cam officially as managing director, then he has authority to sign contract by himself on behalf of the company and should be binding. Okay? Otherwise, only the board of directors have that authority. So what if someone without express actual authority signed a contract? Is it possible for that person to have, for the contract to be binding on the company? Well, it is possible if that person has implied actual authority based on the Haley Hutchison case. So in that case, someone was not officially appointed as managing director, but he behaved as one and the company treated him as one. So that's why it's an internal matter and it's implied actual authority. Alternatively, it may be an external matter. How did the company or the board represent to outsider about the authority of this individual, the agent? Okay, so that will be apparent authority based on the Freeman Lockyer case. And if you satisfy all three conditions, it is possible to argue there was apparent authority. In that case, even if that person was not officially appointed as such, it is still possible the contract is still binding on the company. So condition one, a representation that the agent had authority to enter on behalf of the company into a contract. Okay. Condition two, representation was made by someone or an entity that did have actual authority. And number three, that the other party was induced by the representation to enter into a contract. If you satisfy all three, then it is possible to argue apparent authority, then the contract should be binding. So apply to our situation. Okay, in this case, it's likely Cam did not have expressed actual authority to enter a contract on behalf of the company. So that's settled. Because if he did have expressed actual authority, we do not need to continue the discussion. Okay, it is binding. Okay. However, for implied actual authority, the board only agreed for Cam to travel to the mainland to investigate new opportunities. So it is unlikely, based on Haley Hutchison, Cam had implied actual authority. So even internally, they never said he can go to the mainland to sign a new contract. His job was just to investigate new opportunities. So unlikely to have implied actual authority. Now, what about apparent authority? So you will need to prove number one, the board somehow represented to the other company, PDL, that Cam had authority to enter a contract on behalf of SBL. So that's quite unlikely because here you can see there was no communication. They are not even aware of each other. So condition number one, unlikely to satisfy. But for completion, should still discuss the remaining condition. So did the board have actual authority? Sure, definitely yes. And did the other company rely on representation induced into a contract? So if there was such a representation, PDL did in fact sign a contract, so you can argue the third condition might be satisfied. But since the first condition was not satisfied, clearly there was no apparent authority. So the conclusion is Cam did not have authority to sign the contracts. Okay, so in that case, we need to ask, what about the other parties? Okay, are they protected? Because they have no idea what's going on internally. So that's the reason why we have section 117, which is the statutory indoor management rule. So when you study this topic, you realize indoor management rule, we have the one under common law, which is based on the Turquoise case. That's why it's called the Turquoise rule. But we also have the statutory indoor management rule, which is based on section 117. So subject to 119, in favor of a person dealing with a company in good faith, the power of the company's directors to bind the company is to be regarded as free from any limitation. Okay, so this is the starting point for 117, and it's basically if you're dealing with the board of directors of a company and you sign a contract, assuming they're acting in good faith, then you can assume their powers to bind a company in a contract is free of any limitation, free of any internal rules or internal restriction. And under 2B, you can assume the company was acting in good faith unless you have evidence pointing otherwise. And obviously, the person dealing with the company is not required to make inquiries to check on the limitations. So applying to our situation. So the company's article stated the contracts over 2 years require shareholders' approval. Okay, this is the internal rule. This is the internal regulation. Since that was not done, you will need to see if the statutory indoor management rule can be invoked. So generally speaking, because there's an internal rule, since the company did not obtain the shareholders' approval, you can argue this is something beyond their powers. But since it's an internal rule, we need to turn to the indoor management rule, in particular section 117. So 1172B says you can presume the company was acting in good faith. As such, you can regard that the CAM's power to bind SPL in the contract was free of limitation. Now, authority of the company secretary. So in this case, you can see a modern company secretary is also considered an officer of the company, has ostensible authority. So ostensible authority is similar to apparent authority. You're showing to outsider you have authority to act and sign contract on behalf of the company. So if the company secretary sign contracts connected with administrative matters, then should consider to be binding. So it's not stated in the information where Lily had expressed actual authority, but based on the Panorama case, she may have apparent authority when she's signing contract on administrative matters, such as booking the flights and for hiring cars. The cars, I think you can argue, is administrative in nature, and therefore the contract should be binding. Then about the separate legal entity issue. Okay, so you should all be familiar with this. Based on the landmark court case Salomon & Solomon, a company once properly formed is a separate legal entity. The company is a separate legal person as opposed to the directors or shareholders of the company. And then in Adams and Cape, it confirms that each company in a corporate group is also, each of them are separate legal entity, even if the group operates as a single economic unit. And in China Ocean Shipping case, it explains under what situation would a corporate veil be pierced? Well, how was the corporate structure used? Was it used to evade legal obligations? If so, that's objectionable, and the court has the power to lift the corporate veil. But if the company was using the corporate structure to avoid the incurring of any legal obligation in the first place, that is not objectionable, and in that case, the court would not lift the corporate veil in this type of situation. So application. So based on this Salomon & Solomon, once Star Limited is properly formed, is a separate legal entity. Creditors can only pursue Star Limited for debts owed by Star Limited. Also, based on Adams and Cape, even companies within the same group, they are still considered separate legal entities, and therefore the creditors cannot claim against them, can only claim against Star Limited. And it's also confirmed in China Ocean, and that is unless in the story you can show that the corporate structure was used to evade legal obligation, in that case, the corporate veil may be pierced. But if it is to just avoid, if you set up a company to avoid future obligations, in that case, that is not objectionable, and therefore unlikely the court would pierce the corporate veil to hold other group companies liable. Okay, let's now move on to question number 9. So we have Botanical Holdings Limited. It is a pharmaceutical company whose shares are listed on the main board of the stock exchange. So you can see here, company has undergone some expensive research and development project. It has not launched any new product for several years, and is losing market share. Now, one of the company's directors, Wasim, learns that a new candidate has expressed an interest in joining the board. The candidate is Zain, who is well known due to his successful TV show, has a reputation for turning around the fortunes of struggling companies. Because of his profile, Zain has asked for discussion about his possible appointment to be treated in confidence. So this is information they want to not yet disclose to the public. So Wasim tells his tennis partner Tariq that Zain is likely to join the board. He tells Tariq that if he can afford it, should buy as many shares in the company as possible, as the share price is bound to go up once Zain's appointment is made public. Tariq purchased 20,000 shares in the company. Tariq is the sole director of Alchemy Limited. The board agrees to lend Alchemy $5 million on a short-term basis at favorable rate of interest. Wasim and Aliyah, one of the other directors, are aware that Alchemy intends to use the money to buy shares in BH, but they did not disclose this to the other directors. Alchemy subsequently purchased 100,000 shares in the company. So a few weeks later, Zain is appointed to the board of the company. They issue a press release, got a lot of media coverage. The share price quickly doubled. Tariq sold his shares and Alchemy sold his shares as well at considerable profit. So after reading story, I think you can clearly see this is about inside information, about possible inside dealing, and also possible financial assistance. So for these two topics, you'll be covered by Learning Outcomes 4. And the comments from the examiner is most candidates able to provide relevant definition of inside information and connected person, but only a few could identify the relevant sections and possible defense. In terms of the financial assistance, many candidates able to identify the issue, explain the rules, so that's good. Okay, so you will recall the last time in the previous paper, we look at possible insider dealing situation. I suggested you will make it more manageable by looking at by individuals, whether that person committed insider dealing. So let's start with Wasim first. I think the possible offense will be under subsection 3. A person who is connected with listed corporation has information shall not disclose the information to another person who may make use of the information for the purpose of dealing. And then subsection 5, you can see a person who has information. This is for Tariq, which is known as inside information, and then receive the information from a person he knows is connected and then shall not deal in the listed securities. Okay, so what about definition of inside information? So we covered that previous question before, is specific information about the corporation, about a shareholder, or about officer of the corporation, or the listed securities, which is not generally known to the public, but if known, likely to materially affect the price of listed securities. So that's the definition of inside information. And connected, we saw this last time, defined in section 287. If you're a director, employee, or substantial shareholder, most likely you're connected for the purpose of insider dealing. Okay, so let's do application 1 at a time. First of all, Wasim. Okay, he is director of the company, so therefore he will be a connected person under section 2871A. Now, the joining of Zain as a director of the company would likely be inside information. Okay, first of all, it is about a possible officer of the company, because once he joins, he will be a director because he will join the board. And the information is not yet known to the public, but once known, is likely to materially affect the price of the shares. So as I said, all you need to do is likely to affect already fit in a definition of inside information. But for this particular story, they said the share price doubled, so that's why it increased by 100%. So when Wasim disclosed the information about Zain joining the board, he had committed an insider dealing offense under section 2913. Now, when Tariq received information from Wasim, he is likely to know Wasim was director of the company, the listed company BHL, and that the information about Zain joining the board will be inside information. So when he purchased the shares in BHL, he had committed or likely to commit inside dealing offense under Section 291, subsection 5. Okay, so possible penalties, we've seen this before. It's possible if convicted on indictment to a fine of 10 million and possible imprisonment for 10 years. There are also possible orders. I quickly went through them last time. Is disqualification order. If you're a director, then you can issue an order saying you can no longer be a director of a listed company, maybe for 1 year, 3 years or more. Cold shoulder orders where the SFC would not basically pay attention to you or cooperate with you. Disciplinary referral order if you're already part of a professional body. For example, if you're a lawyer, a CPA, or maybe a company secretary, then this conviction of insider dealing would be informed to the professional body, who may hold disciplinary hearing to decide whether you can continue to hold your professional qualification. And disgorgement order is if you make some profit from insider dealing, most likely you have to pay those profit, return them. That way you will not gain from insider dealing. Okay, now let's look at financial assistance. So this is covered under Section 275 of the Companies Ordinance. So if a person is acquiring or proposing to acquire shares in a company, the company must not give financial assistance directly or indirectly for the purpose of the acquisition. Okay, so if you have people buying shares in your company, they're supposed to invest money into your company. Okay, so it would not make sense for the company to lend money to that person to buy shares. In that case, no new money is invested into the company. So that's the reason why you have these sections. So if a company contravenes these sections, the company and every responsible person commits an offense liable to a fine of up to 150,000, imprisonment for up to 12 months. So apply to this situation. It was stated that Wasim and Aliyah, both directors of the company, were aware that the loan to Alchemy would be used to purchase shares in the company. So prima facie, that would may amount to a breach of Section 275(1). Does not appear that any of the exceptions in the subdivision applies. So the possible penalties is the fine and also the possible imprisonment. Okay, so we have finished talking about the November paper. We are now moving forward to June, moving backward, I should say, to the June 2022 paper. First of all, some general comments. So you can see the overall performance was adequate, but the answering technique was generally weak, especially in Section B. So many candidates failed to correctly identify relevant issues and rules in Section B. So we've seen this about 5 times already. So it continues to be a problem, but I think it's not a problem for all candidates. So I think those who perform poorly may have this problem, but those who perform well, I guess, obviously have overcome this problem. So instead, they review rules and cases that were not relevant to the question. So we've seen this before. There's no point identifying issues that's not relevant and explaining rules that's not relevant. Then it's very difficult to get marks. So that's why you want a high return on your investment of your limited time and your effort. So that's why pay close attention and just take a little bit longer, a few more seconds to consider what is the issue at hand. So some candidates fail to back up their conclusion with explanation or discussion. So this is quite common. Some would just jump to the final answer. Okay? So as an exam technique, Section B, each question is worth 25 marks. Just because you arrive at the final answer immediately, yes, guilty of insider dealing, that will not score you 25 marks. Okay? Is by identifying the relevant section, going through explaining the relevant criteria, applying to the facts to say whether it is a breach or not. That will give you a lot more marks. So that's why I think this is what the examiner is trying to say. Do not just jump to your conclusion. You need to explain and discuss. So candidates are reminded they expect to focus on the relevant issues, especially for Section B, which likely can have more than one issue. So you can see on of the many past exam questions we have covered so far, each of the section B questions, at least 2 issues, each of them, okay? The only exceptions, I would say, is insider dealing. Then in one of the questions in 1 year, it's just insider dealing, okay? But the one we saw before is insider dealing plus financial assistance, so be careful of that. And of course, where required, then some discussion and some analysis will be required. Okay, so let's move on to this question, question 6. Green Cloud Solutions Limited provides consulting service to a variety of small and startup business. Company was incorporated in 2018, traded profitably for the first 2 years, but then in 2020 lost a major client and has not made a profit since. So it's a possible loss-making company. So the directors are Usman and Rifat. The company issued 5,000 ordinary shares. Usman and Rifat each own 1,000, and remaining are owned by friends and family of the directors. So the company adopted the model articles. The additional clause is the directors may not enter into any loan agreement on behalf of the company or grant security over any assets of the company unless it has first been approved by ordinary resolution of the company. So you can see this is an internal requirement, internal rules, and that is if the directors who usually have the power to enter into contracts on behalf of the company, for these type of situation, there is an additional requirement, need approval by the shareholders. So Usman and Rifat are concerned the company is beginning to struggle financially, decide to raise some additional finance. Company approached Q Bank to obtain a loan. So on behalf of the company, the directors enter an agreement in which Q will lend $1 million secured by a fixed charge over GSL's premises. Loan monies are paid into the bank account. Usman and Rifat still wish to raise further capital, so they caused GSL to allot 2,000 new ordinary shares, which are issued to Mariam. Some of the shareholders are beginning to complain that Usman and Rifat are doing a poor job of managing the company. They are suggesting directors should be removed. Some shareholders have expressed concern the company is unable to pay the loan from Q. Directors argue the loan agreement is void in any event because it was entered into in breach of the articles. So in order to give shareholders confidence in the company, directors recommend a final dividend at a rate of $1 per share is paid. Mariam agrees and dividend is declared and paid. So advice on the validity of the actions of the company and its directors, in particular the loan agreement, the allotment of shares, and declaration of dividends. So these are quite specific, want you to discuss about each one of them. Okay, so for these topics, they're mainly from Learning Outcomes 1 and Learning Outcomes 4. So you can see the examiner's comments. He said, basically, many candidates only identify 1 or 2 of the above issues. So these are the 3 that needs to be discussed. And most only focus on the issue of breach of director's duties. So again, in the past, this used to be a habit of some candidates is when unsure, they just talk about director's duties, okay? But let's go back to the question. When the examiner is quite specific on what the examiner wants you to discuss, and I think some of the topics are quite obvious as you read the story, I think it's better to stay with those. So because there is an internal rule and they didn't follow, so therefore indoor management rule definitely would be something you want to talk about. Shares were allotted, so that's why I need to talk about allotment of shares. And if there's declaration of dividends, you need to talk about that as well. Okay, let's focus on the first issue, indoor management rule. So we have already looked at this before. It's section 117, the statutory indoor management rule, and it's basically protecting the outsider. If a company is acting in good faith in the company, then they can regard the director's ability to sign a contract that will bind the company to be free of any limitation. You can presume that party is acting in good faith and there's no need for them to inquire. Okay, of course, if that person already knows about the arrangement and knows that you do not have power and sign a contract anyway, then cannot ask the indoor management rule to give you protection. Okay. So application. The company's articles do not allow the directors to enter into a loan agreement unless it has first been approved by the shareholders. So applying section 1171, if the company QBank was acting in good faith, it can regard the director's power to bind the company in the loan agreement to be free of any limitation. Since there's no evidence to the contrary, we don't think there's anything suspicious. We can assume QBank was acting in good faith and not required to make any inquiries on the limitation of the director's powers. So in conclusion, it's likely the loan agreement is binding. So that's the first issue. Okay, then moving on, we can look at the issue of the allotment of shares. So here you can see is we have looked at this section before. It's section 140, and it's basically saying that the directors cannot allot shares unless, for example, under 141, you have approval in advance by the shareholders and you need an ordinary resolution. So apply that to our situation. Usman and Rifat cannot allot the 2,000 shares to Miriam unless they have shareholders' approval in advance. So an ordinary resolution will be required. Since Usman and Rifat together own 2,000 out of 5,000 shares, that's only 40%. So they would need other shareholders' agreement to pass the resolution, to pass the ordinary resolution, which is a simple majority. As per section 140 subsection 6, the allotment should still be valid. However, if Usman and Rifat allotted the shares without shareholders' approval in advance, they may have committed an offense and will be liable to a fine and possible imprisonment. So assuming Miriam was not connected with Usman and Rifat, it is possible still to claim the allotment was valid. Okay, so what about the declaration of dividends? So we can look at the articles. The company may at a general meeting declare dividends, but the dividends must not exceed the amount recommended by directors. So obviously, if you recommend a certain amount for dividends, you either say yes or you say no. However, a dividend may only be paid out of the profits in accordance with the part we looked at before, and that's the profits available for distribution, which is the accumulated realized profits, which should be more than the accumulated realized loss. And also we have section 301, and it's talking about, we've seen this before, if at the time of distribution, the member knows or has reasonable grounds for believing that there's a contravention, meaning a dividend was distributed not out of available profits, then in that case, the member is liable to repay the money back to the company. And in this case, the shareholders knew the company had no profits and the distribution contravened the statutory provision, so have to repay the dividend. So the shareholders receiving dividend need to give the money back to the company. Okay, application. So in this case, Usman, Rifat, and Marianne own 4,000 out of 7,000 shares. It's likely they have sufficient vote to pass a resolution. Okay, more than half. However, under section 297, they can only pay dividends out of distributable profits. Since the company was only profitable for the first 2 years and made losses ever since, the distribution may have been unlawful. In other words, the accumulated loss may have been greater than the accumulated profits. So based on this section, if Miriam knew or had reasonable grounds to believe the dividend was paid in contravention of that section, then she will be liable to repay the dividend back to the company. So as confirmed in this case, it is not necessary for shareholders to have a full understanding of legal position. So as you can understand, as a shareholder, if you have a general understanding, we have not made profit, but it's still paying dividend, that may already be enough. It may not be required for the shareholders to have a full detailed legal understanding of the situation. So conclusion is likely they will need to repay the dividend back to the company. Okay, so let's now move on to question number 7. So here we have a situation about a company. First of all, they decide to leave their employment and they start their own business via a company. Dan and Kareem began preparing for the new company's incorporation. They agreed to rent some office premises and equipment from Eric. The rental contract was signed by Dan on the 29th of January. And here it says signed by Dan for and on behalf of Red Pixel Limited. On February 8th, Red Pixel was incorporated and the certificate of registration was issued. Okay, so while you're reading the story, once you get up to here, hope you can already at least guess one of the topics that most likely will need to be answered for this question. We have a company about to be incorporated. Before incorporation, they sign a contract on behalf of the company. Okay, so clearly this would be a pre-incorporation contract situation. So I would write down pre-incorporation contract on the side to remind myself, and then later on I can tackle that question. So the company has an issued share capital of $1 million divided into 10,000 shares. Dan and Astrid owns 2,500 shares each, and Kareem owns 5,000 shares. So the three of them are directors, and Kareem is also appointed as company secretary. The company adopted the model articles, and then in March, Dan learned that Kareem had set up her own company specializing in mobile phones. So mobile phone repairs, and she had been spending most of her time on this rather than working for Red Pixel. Dan and Astrid confronted Kareem and there was a big argument. They asked Kareem to step down from the board, but she refused. So there's a disagreement, they're unhappy, they asked her to stop being a director, to resign as director, but she refused. So Dan and Astrid proposed to include new Articles 22A to remove Kareem. 22A provides that a director will be required to vacate office if the other director so requires. So no rent has been paid on the office premises. So Eric wrote to Dan stating he will repossess the premises and equipment in 10 days unless the overdue rent payment are settled. So advise the directors of Red Pixel. So you can see the question here this time is not as specific. The question itself did not explicitly tell you which issue to discuss or which area to discuss. But hopefully as you read the story along the way, you can already guess some of the key issues to be discussed. So, pre-incorporation contract, as I mentioned before, removal of director and alternate articles. They're from Learning Outcomes 1, 2, and 1. So candidates were required to discuss these issues. Only a few candidates managed to explain the concept of pre-incorporation contract, while most only focus on the issue of breach of director's duty. So two things. Number one, of course, is after reading those first two paragraphs, hopefully you can work out it's about pre-incorporation contract. So unfortunately during that year, not many candidates discussed that, but doesn't matter. If this come up again, I'm sure you will all be well prepared. And again, you can see when unsure what to answer, a lot of students that fall back is talk about breach of director's duty. So just be careful. If these topics do come up, obviously you want to focus your time more on here rather than write director's duties for all the questions. Okay, so first of all, pre-incorporation contract. The starting point will be section 122. So this section will apply if a contract purports to have been made in the name or on behalf of a company before the company was incorporated. So this is quite factual, whether it is or it is not. Okay, so if it is not, section 122 will not apply. Okay, but if the answer is yes, then of course it will apply. So let's continue. So subsection 2, subject to any express agreement to the contrary. The contract has effect as a contract entered into by the person purporting to act for the company, and the person is personally liable on the contract and is entitled to enforce the contract. Okay, so subsection 2 is very important for the person signing the contract. Because even though when you sign the contract, you wrote down this is signing on behalf of the company, Since the company has not yet been incorporated, it did not exist at the time of the contract. Therefore, the contract is not binding on the company. On the other hand, since that person signed the contract himself or herself, the contract becomes binding on that individual, on that person, and of course that person can enforce the contract as well because it belongs to that person. Okay. Now, subsection 3, the company may ratify the contract to the same extent as if the company had already been incorporated and the contract has been entered into by an agent acting without the company's authority. So what does ratification mean? It basically means the company say it is okay, we will take this contract. Okay, so this is something new. This is something that goes beyond the common law view of pre-incorporation contract. Because what it is saying is despite the fact that the company did not exist at the time the contract was signed, after its incorporation, the company can ratify the contract and basically saying despite the lack of contract, despite the lack of authority, despite the fact that the company did not exist at that time, we will take the contract. We'll ratify the contract. In that case, the company can be liable for the contract and the company can enforce the contract after ratification. So application. So in this case, Dan signed the rental contract on the 29th of January before the incorporation of Red Pixel on the 8th of February. So here you can see the dates are important. So when you do application, it will be good if you also wrote down the date to show that the contract was signed before the company was incorporated. In that case, section 122 would apply. So applying section 122 subsection 2 first, then would be personally liable for under the contract and therefore personally liable for the outstanding rent under the contract. Based on the facts provided, it does not appear there's any ratification under subsection 3. Okay, Dan can ask the company to do so, but if the company did not ratify the contract, then it will become a contract for Dan, and Dan will be liable for the overdue rent. Okay, removal of director, we've covered this many times. So you can see is section 462. You can do so by ordinary resolution and general meeting. By the shareholders, all you need is a simple majority, but you need special notice. We'll cover that before. Whereas if you want to do alteration of articles, then under section 88.2, you can do so first of all by special resolution. But even if you have enough votes and you pass the special resolution, if someone challenge the alteration of articles, then under Allen and Goldreeves, you need to show that you exercise the power to alter the articles bona fide for the benefit of the company as a whole. So application. Here you can see it's possible to remove Kareem if they can pass the ordinary resolution. But since Kareem holds 50% of the shares, it's unlikely Dan and Astrid can obtain enough votes to pass a resolution. Okay, so you need ordinary resolution, you need a simple majority. That means you need more than 50%. So since Kareem holds 50% herself, and I doubt she would vote yes to removing herself, so that's why unlikely to have enough. Okay, so what about the backup plan? Can they alter the articles? So the hurdle is even greater because they need a special resolution. Again, it's unlikely Kareem will say yes to such an amendment to the articles because it means it will be easier for Kareem to be removed as a director, so they will not have enough votes. Even if somehow they have enough votes and they pass a special resolution, if Kareem challenged the amendment, then of course they will need to show that the amendment was bona fide for the benefit of the company as a whole. So in conclusion, it is unlikely they can remove Kareem as a director of the company. Okay, it's possible after covering all this and you still have time, you can talk about possible breach of directors' duties, but definitely that's not the main issue. So the ones discussed so far, as explained by the examiner, they should be the main focus for this question. Okay, let's now look at question number 8. We have Saul, Thomas, and Benjamin. They have run a successful business in partnership for the past 5 years. They decided to incorporate the business and a new company, STB, is created. So Thomas and Benjamin become directors and are each issued 3,000 shares in the company. A further 1,000 shares are issued to Leah, a friend of Saul's. So STB adopts the model articles but have several provisions stating the following. Number one, no directors can be removed without their prior consent. Number two, each director is to receive a salary of 1.5 million per year. And number three, the company cannot enter into contract worth 100,000 or above unless first approved by resolution of the company. So these clauses are quite familiar, so hopefully you can recognize them as we're reading them. So the company has been trading successfully. No dividends have been paid as all profits were retained by the company, with the directors drawing only the salaries of 1.5 million each year. So again, we have a situation where no dividends are paid, but it does not matter because the directors own shares in the company. So even though they don't receive dividends, they actually receive salaries of 1.5 million each year. So earlier this year, Benjamin had an argument with Thomas and Saul over the future of the company. Following this argument, Thomas and Saul made all the business decisions in advance and outvoted Benjamin at all the directors' meetings. Recently, Thomas and Saul have voted to remove Benjamin as a director at a general meeting and also have voted to distribute the company's profits by increasing the director's salaries to 3 million per annum. So we've seen these type of actions before. So STB has recently invited tenders from several suppliers as part of an exercise to select a new catering company. Benjamin notes that during the tender process, Thomas accepted a gym membership as a gift from San June Limited, a supplier of catering services. Benjamin also had learned that following the tender process, Thomas signed a contract worth $100,000 purporting on STB's behalf with Sandune. Thomas is a majority shareholder and director in Sandune, but he did not disclose this to the other directors. So all these are very familiar to us. So first of all, director's duties, unfair prejudice, winding up company. All these are from learning outcomes 2, 3, and 5. So you need to talk about director's duties. So most candidates did well, demonstrating understanding of relevant rules and concepts. For part B, most candidates managed to explain the concepts for section of concepts as well as the unfair prejudice remedies. So it looks like they did well in this one that year. Okay, so first of all, for the director's duties, Thomas accepted the gym membership and also signed the contract. So you can see, we've seen this case before, the Aberdeen Railway case is the conflict of interest. Okay, if the director was acting for the company in negotiating a contract as a buyer, but then also as a partner of the supplier, that would amount to a conflict of interest. Because the buyer, as you may imagine, would hope to buy at a lower price, while the seller would hope to sell at a higher price. So in that case, clearly, that would be a conflict of interest, and if it's not declared, then of course the company could avoid the contract. In another case, the directors breach duty when received secret commission and bonus from the service provider, so clearly will be dismissed and must account for profits to the company. And we've seen this before in the Akai case. If you are doing something that is contrary to the constitution of the company, or for example, against one of the clauses in the articles, that can amount to a breach of duty to act in the interest of the company. Okay, so let's do application. So Thomas received a gym membership from Sandune, and then without disclosing to the company, awarded a contract on behalf of the company to Sandune. So that's quite disturbing, because you think about it, he received a benefit, and then in return, as director of the company, he awarded a contract to that company. So as confirmed in the Aberdeen case, you have a possible conflict of interest and therefore should disclose interest to the company. You can also argue that there's a breach of another duty, and that's the duty of a director not to receive secret profits. So here, Thomas received secret profit in the form of a commission, or you may even say it's a bribe, without disclosing to the company, and therefore he'll be required to account for profits. Okay, so in Hong Kong, as you know, it's very disturbing to do something like that. In addition to breach of director's duty, may also have problems with the ICAC as well. But that's outside of scope. But at least from a practical point of view, you can see quite troubling behavior there. So since the contract was worth 100,000, should have obtained approval by a resolution of a company. So the resolution say you need to obtain approval, and they did not do that. So as stated in the Akai case, by acting contrary to the articles, that may amount to a breach of the duty to act in the interest of the company. So you can see more than one breach of director's duty by Thomas here. Okay, so what about Benjamin? Here, he did not attend the meeting. So we have seen this before. It is under section 465. It is a director has a duty to exercise reasonable care, skill, and diligence. Okay, and what does it mean by reasonable care, skill, and diligence? It is what you expect from a reasonably diligent person. First, the objective test with general knowledge, skill, and experience that would reasonably expect of a person carrying out that function of a director in that company. And then the subjective test is depending on the actual knowledge, skill, and experience that director has. We also have the Dorchester Finance case where the directors were held liable for negligence. Those who attended the meeting failed to exhibit necessary skill and care, while those who did not attend the meeting failed to perform any of the duties as directors. So you can see, if you're a director of a company, you must exercise your duty to exercise reasonable care, skill, and diligence. If you attended a meeting, you must do so carefully, read the information carefully, make the decision carefully. If you did not even attend the meeting, then you still have breached this duty. Just is much worse because you did not even attend, so you failed to perform any of the duties of the directors. So application. As a director of STB, Benjamin should exercise reasonable care, skill, and diligence to manage the company under section 465. So although the directors may not agree with each other and may be outvoted by others, Benjamin should still continue to carry his role as a director. So as stated in the Dorchester Finance case, not attending meeting could amount to not carrying out any of the duties of a director. So conclusion, if held to be negligent causing loss to the company, Benjamin, also the other directors may be held liable for the losses. Okay, so what about unfair prejudice? So we have covered this in the previous questions before. So it's covered by section 724. So here is if a member petitioned the court, then the court may consider to do something if it considers that number one, the company's affairs generally conducted in a way unfairly prejudicial to members or one of the members, or number two, an actual or proposed act or omission, so a particular transaction they enter into, something they do or something they did not do would be considered prejudicial, then the court will exercise its powers under 725. So 725, the court may make any order it thinks fit for giving relief in respect of the matter. So it's drafted broadly intentionally because it's hard to anticipate what may happen. So to ensure the court can resolve the situation, that's the reason why they give the broad power to the court. Make any order that it thinks fit for giving relief in respect of the matter mentioned here. And then we've seen this case before. Directors failure to pay declared dividend and instead pay management fees to themselves amounted to unfair prejudice. And this other case, entering into agreement in which substantial profits were paid to a director and other non-shareholders, and a consistent failure to even consider whether to declare dividends from the remaining profits amounted to unfair prejudice. So this is quite an extreme situation. If the company made substantial profits for so many years, but only some people got paid, but the other people did not. In particular, the other shareholders did not get a chance to have received dividends because the directors did not even consider whether to declare dividends or not. So that would be an example where it would amount to unfair prejudice. So for the winding up, we have seen this before as well. You recall you can wind up a company by petition under Section 1791. But in order to do that, you must be able to satisfy the court that you have a valid ground under Section 177. So 177.1, you can see a company can be wound up if a company has by special resolution resolved the company be wound up by the courts. So A is a voluntary situation where the members believe it's better for the court to wind up the company, then they will use A. B is if the company did not commence business or suspends its business for a whole year. C is where everyone has disappeared. Company has no members, okay? D is quite common in practice, where a company is unable to pay its debts. In that situation, most likely, it will be the creditor, a creditor who would petition the court to wind up the company. Under this ground, the company is unable to pay its debts, and if that's the case, you would follow Section 178, where you would issue a statutory demand for the debt to the company, and if after 3 weeks still unpaid, then it's deemed the company is unable to pay its debt. You submit these documents to the court, then the court will say, ground D is satisfied. And E is when an event specified in the articles for the company to dissolve has occurred. So for some companies, at the time of inception, the time of incorporation, they already state in the articles, if this happened, we will close down the company. Okay? For example, we set up a company to achieve this purpose. Once that purpose is achieved, we'll close down the company. That's one possibility. Or if it turns out the shareholders can no longer invest money in the company as required, we'll close down the company. So once that event is specified, then you can go to the court, apply to the court, and then show the information, and that's a possibility. And the last one we have seen before is the court is of the opinion it is just and equitable, the company should be wound up. That's also possible as well. Okay, so in terms of court case, we have seen this before, is the Ibrahimi and Westbourne Galleries case. So the company was a quasi-partnership. First of all, they started the business together. Then they decided to incorporate the business. It was formed on mutual trust and confidence to manage the business together. And due to a breakdown in the relationship, they no longer have trust and confidence, and maybe one or more of them excluded from management. Then it was decided in that case that the company should be wound up on just and equitable grounds. So you formed it based on that mutual trust and confidence. You no longer have that anymore. So it is right to close down the company, return the money to each of the shareholders, and everyone can go their own way. And then in the Grace and Biaggioli case, we have seen this before, irreconcilable disputes in a small private company, a share buyout order may be more appropriate. So you can see this is one of the options the court can use if it is decided there is unfair prejudice at play, and then a way to finish is for the court to issue the buyout order. And the buyout order is either asking the other shareholders to buy the shares or asking the company to buy the shares from the shareholder. Okay, so let's do application now. So in this case, the company has been profitable for many years. No dividends have been paid, and Tom and Saul had instead doubled the amount of salaries for themselves. Director salaries from 1.5 million per year, which is a lot, to double to $3 million per year. So this resulted in the profits of the company being distributed to Thomas and Saul by way of director salaries. You can see, earn so much profit, but no profit distributed to the shareholders by dividend, but distributed by director salary, because some of the shareholders are directors. But Benjamin, who is a shareholder, was removed from the board. He's no longer a director. So the director's salaries, he would not receive anymore. So you can see that's why it is unfair prejudice. So applying Grace and Biaggioli, if the company was profitable, should declare a dividend. But if the directors refuse to do so and instead distribute the profits to only some of the shareholders by way of director salaries, and have also substantially increased the director salaries, that may amount to unfair prejudice. Okay, so on the issue of winding up, Saul, Thomas, and Benjamin ran a successful business as a partnership before incorporating business. As such, it's likely that STB was formed as a quasi-partnership with the mutual trust and confidence and managing the business together. After the argument, obviously there was a breakdown relationship. There's no more trust and confidence, and Benjamin was also excluded from management. It's therefore possible for Benjamin to petition the court under Section 177(1)(f). That will be the grounds, okay? It would petition under 1791, but you need a valid ground. That will be the ground, is to wind up the company on just and equitable grounds. However, winding up should only be ordered. It was the only or preferred remedy. So based on Grace and Biaggioli, the court may make a share buyout order instead. So you can see it is permitted for Benjamin to petition the court to wind up the company. He has a valid ground under Section 1771(f). Unfair prejudice, the breakdown of relationship, the quasi-partnership was proven. So normally that's already sufficient for the court to wind up the company. However, the court in the court case explained winding up is a last resort. Okay, it's a serious outcome, ending a company. So the court will ask, are there any alternatives? So if there's an alternative, then the court may not order winding up. So in this particular story, you can see the alternative is a share buyout order. It asks the shareholders to pay the money back to Benjamin. He can take his money and go invest in something else. And in a way, everyone will be happy. So that's why in this case, it is possible for the court to make an order for Saul and Thomas to buy Benjamin shares at fair price. So the share buyout order is not just buying the shares. Okay, you should also buy the shares at a fair price. Otherwise, it would not be fair to Benjamin. Now, if it was a listed company, that's not so difficult because listed shares already have a market price. But for a private company, there's no existing market, there's no secondary market. In that case, the order must clearly state, must be purchased at a fair price, then it will be fair to Benjamin. Okay, then for the last question for June 2022, we have Riverside Taxi Limited. It is a taxi company operating private hire vehicles in Hong Kong. The company was incorporated in 2018 by two directors, Marco and Eliza. They are also the only shareholders, each of them holding 250 shares. Now, the global pandemic has had a serious impact on private hire vehicle sector, and Riverside has experienced financial difficulties as a result. So by 2021, the end of 2021, the company has reached its overdraft limit with Step Bank. In return for extending the overdraft, Step Bank requires security in the form of a floating charge over all of the company's assets. Marco and Eliza agreed. They decided to use some of the overdraft funds to repay an unsecured loan of $100,000, which Eliza has made to the company a few months earlier. So this is quite complicated, but you can see what it may be about. Okay, it's about a floating charge, talking about it is granted to a bank during financial difficulties. So it is possible the company may go into liquidation soon. So would the section apply against the floating charge to make it invalid? So I think most likely this is something I will need to discuss. So I will probably write down either section 267 or write down the floating charge, whether it is valid or not, next to the second paragraph. Now, Riverside continued to struggle financially. In January 2022, the auditor told Marco and Eliza it was unlikely the company would avoid insolvent liquidation. So the auditor of the company already said the company is in financial trouble. So Marco and Eliza disagreed. They were confident that the market would pick up again and they would be able to trade their way back to financial stability. Unfortunately, the company's fortune did not improve. The company still has substantial overdraft and it owes $100,000 unpaid tax to the Inland Revenue Department. So far in this third paragraph, you can see is initially the auditor said the company is in financial trouble. Marco and Eliza, they did not agree with the auditor. They believe if the economy improve, they should be able to trade out of the trouble, continue to do business, earn more money, and then the company should be fine. Okay. Unfortunately, it turns out not to be true. They have used up their overdraft and they also owe money to the tax authority. The company has not paid its employees' wages for the past 6 months, and there are a number of suppliers and other unsecured creditors awaiting payment. So the directors are concerned about the company's futures and seek your advice. So advise the directors on the legal implication if the company goes into liquidation and the order of distribution of the company's assets on liquidation. So some topics very familiar, but factually some circumstances slightly different. So I think it's worthwhile to go through this question as well. Okay, so the topics would be the validity of floating charge, unfair preference, and also fraudulent trading. So would be relevant to learning outcomes 3, 4, and 5. So based on the examiner's comments, and most correctly refer to relevant sections for 267 and 275, but only a handful demonstrate an understanding of the concept of unfair preference and fraudulent trading. So it seems they are all quite familiar with 267, but not as familiar with unfair preference and also fraudulent trading. So we'll be discussing them as well. So first of all, validity of floating charge. So we have covered this before. It is section 267, and you remember the starting point is if a floating charge was granted at a relevant time, it is invalid. Okay, that's the starting point. That's the general requirement of 267 subsection 2. So that's why you need to ask relevant time period. So we have seen this before. We're dealing with a person not connected with the company. So relevant time, there's two components. Component number one is 12 months ending from the day the company commenced liquidation. That's number one. And that the company at that time of granting the floating charge is unable to pay its debts, or in consequence of granting the charge is unable to pay its debts. Either one. Okay? So need to satisfy both in order to have relevant time period. Okay? Now, even if the transaction occurred during the relevant time, based on the definition we looked at, there's still the exception under subsection 3, and that's the new money exception. We've discussed that before. Is the amount, is the aggregate or the value of so much of the consideration for the creation of the charge that consists of money paid to the company. Okay? Was this a normal commercial transaction? The company granted a floating charge to the other party. What did the company get in return? Did the company receive new money? For example, a new loan? If the answer is yes, then good. The exception under subsection 3 is invoked, or it applies, and therefore the floating charge remains valid. And then we also have section 184. Why is this important? Let's go back to the previous slide. Because when we count the relevant time is 12 months counting back from the date of the commencement of winding up. So when is that date? We need that date in order to calculate the relevant time in order to answer the question whether a floating charge was granted during the relevant time period or not. So that's why we need to look at section 184, and most of the time it is subsection 2. Okay? The date of commencement of winding up, a court winding up, will be the date when the petition was presented to the court. Okay, so application. So based on the information provided, State Bank is not connected with Riverside. As such, the charge granted in December 2021 likely to fall within the relevant period of 12 months. Okay, so since they are not connected, relevant period is 12 months and the solvency test. Okay, so since Riverside experienced financial difficulties and have reached its overdraft limit, it is likely it could not repay its debts at the time. Okay, so you can see here is the additional requirement for relevant time period, in addition to the charge granted within 12 months, at the time of granting, was the company able to pay its debts? If the company cannot pay its debts, this part of the requirement is satisfied, therefore it is within relevant time period. So therefore, the floating charge would not be valid unless you satisfy the new money exception under subsection 3. Okay, we'll basically need more information to decide this one. But before we go there, we can go back to our story to take a look on the granting of the charge. Okay, you can see here is because in this situation, the company basically reaches overdraft limit. So in return for extending the overdraft, State Bank requires security in form of a floating charge. So we need additional information. How much was the overdraft extended by? Okay, so for example, if they increase the overdraft by, let's say, 100,000 or 200,000, that amount may qualify for the new money exception. So clearly not the full amount will qualify, but it may be possible some of the amount may qualify if it is under the new money exception. Okay, so we finished talking about the floating charge. We can now go and take a look at the next issue. It's the matter of unfair preference. In particular, is despite the financial difficulties, they used some of the money to repay the loan that was lent to the company by Eliza. Okay, so the relevant section for unfair preference will be section 266. So let's start with subsection 2. If the company has, at a relevant time, given an unfair preference to a person, the liquidator may apply to the court for an order. Okay? And what is that order? Well, look at subsection 3. The court may make an order that it thinks fit for restoring the position to what it would have been if the company had not given that unfair preference. So we've seen this phrase before. An order that it thinks fit is deliberately quite wide because it's hard to foresee all the different situations that may arise. But the underlying objective is to make an order that restore the position as if the unfair preference had not been given. Okay? So, so far so good. Subsection 2 must be within the relevant time. We'll look at that very shortly. So very similar to 267. The transaction need to occur within the relevant time, otherwise the section will not apply. Okay, but for the court to make an order to restore the position, the court must not make the order unless the company was influenced in deciding to give that unfair preference by a desire to produce the relation to that person to the effect mentioned in 266A1B. So what is 266A1B? It's basically the company does anything or suffer anything to be done which has the effect of putting that person in a position which, in the event of the company going into insolvent liquidation, will be better than the position that person would have been in if that thing had not been done. So this sounds like a lot, but what it's trying to say is the unfair preference. Did it put the person in a better position than it would have been in once the company goes into insolvent liquidation? Okay, so the key term, of course, is insolvent liquidation. What's the difference? Insolvent liquidation means the company do not have enough money to repay all the creditors in full. So priority matters. Whether you're paid first, second, third, or fourth, it matters. The sooner you are paid, the higher you are in priority, the higher chance you get something. The later you are paid, the lower you are in priority, the greater the chance you get paid nothing. Okay? So let's go back here. So in other words, the court must not make an order if the company was not influenced by a desire to prefer. Okay? But if so, then it can use this section. However, this desire to prefer, as described in the industry for subsection 4, it is presumed, unless the contrary is shown, if the unfair preference is given to a person connected with the company. Okay, so if the unfair preference, the claim unfair preference is given to a person connected to the company, it is presumed it was a desire to prefer, unless the contrary is shown. In other words, the liquidator asking the court to use the power under Section 266 do not need to prove there was a desire to prefer, because it's a connected party. Whereas the other party, meaning the connected party in the company, they will have the onus of proof. They will need to show, because they need to show the contrary is shown. So they need to show it was not an unfair preference, there's no desire, okay? So what would amount to unfair preference is actually defined in Section 266A. First part is the preference, unfair preference given to a person who is a creditor of a company or a guarantor of a company. So that's condition number one. Condition number two is putting that person in a better position in an insolvent liquidation. Okay, let's look at relevant time. So relevant time for the purpose of unfair preference, first of all, you need to ask the question, are they connected with the company? If the answer is yes, then relevant time is 2 years. It's longer. Okay? If it is not connected, any other case, then the relevant time is only 6 months. It's shorter. So it's basically protecting the normal commercial transactions. So if you're not connected, after 6 months, you don't need to worry. 266 should not apply to you. Okay? Now, of course, we also have the solvency test. So the time mentioned above is not relevant for 265D, which is transaction and undervalue, and 2662, which is unfair preference, unless either of the following is satisfied. That is, company is able to pay its debt or not, or as a result or consequence of unfair preference, the company not able to pay its debt. So this is an additional requirement. Okay, so let's apply all this to the facts in our story. So first of all, we have the unsecured loan of 100,000 made by Eliza to the company. Okay, so keep in mind this is unsecured loan, unsecured creditors. So in terms of the priority, it's pretty much the bottom. Okay, excluding shareholders, because in an insolvent liquidation, the shareholders would receive nothing. So in that case, originally, Eliza was in a position of unsecured creditor. She will be paid last. Okay? Now, here they repaid the loan to her immediately. Okay? Once the overdraft limit was extended. So in that case, number one, Eliza was a creditor, unsecured creditor. Number two, this action of repaying her earlier placed her in a better position than she would have been if the company entered into insolvent liquidation. Because as unsecured creditor, she has very low priority. Most likely, she would not be repaid. So now what they have done is she got repaid if they did not do that particular unfair preference, she would not have received anything. So she's $100,000 better off. So as she is a director of shareholder company, she is a connected person. The repayment was made in December 2021. So you recall in the earlier slide, the relevant time for connected person is 2 years. Okay, so it was within the relevant time, it's December 2021. Since the company was in financial difficulties already, you can also satisfy the condition that the company could not repay its debts at the time when they gave the unfair preference of repaying her loan of 100,000, unsecured loan of 100,000 earlier. Okay, because it wasn't due for payment, and if the company entered liquidation, clearly she was placed in a better position than she would have been in if the unfair preference was not given. Okay, so since it's a connected party, the desire to prefer is presumed unless contrary shown. So it is likely that Eliza will need to repay the $100,000 back to the company, which the liquidator would use to repay the other creditors. Okay, the next issue to discuss is fraudulent trading, which is under Section 275 of Cap 32. So what does it say? It says, if in the course of the winding up of a company, it appears that any business or a company has been carried on with intent to defraud creditors of the company, the court may, if it thinks proper to do so, declare that any person who were knowingly parties to the carrying on of business shall be personally responsible for all or any of the debts or liabilities of the company as the court may direct. So this is a very powerful section. You can see it's basically holding individuals to be liable for debts of the company if all these criteria are satisfied. Okay, so let's read or look into these different items closely and gain a better understanding. What does it mean by carrying on business with intents to defraud creditors? So let's go back to my earlier example. Let's say you're a supplier of the company and you decide to extend credit to the company. What does that mean? You deliver goods to the company today and you allow the company to pay you, to repay you for those goods 1 month later. That's extending credit to you because the creditor believes you are financially sound and when it comes time, you will be able to repay me. That's the reason why I extended the credit to you. That's why I gave you the 30 days credit. That's why I gave you the goods. That's why I delivered to you, believing you can pay me. Okay? Now, the directors of a company, okay, generally would be in the best position to know how well or not well its company is doing. So if a company is in financial trouble and it would not be possible for the company to repay anyone, in that case, if the directors still carry on business to order goods from the supplier, that would be an example of an intent to defraud creditors. It's letting the creditors believe that I can repay you, I order goods from you, I accept goods from you, but in the back of my mind, I knew the company would not be able to afford, would not have the money, would not have the financials to repay the creditors. So that's an example of intent to defraud creditors, and that's the reason why Section 275 relates to fraudulent trading. You're trading, you're continuing to trade, but you're defrauding the creditors, okay? And if satisfied, then of course the individual have to be personally liable for the debts. So if the supplier cannot get the repayment from the company, can, under Section 275, claim against the individual. So Secretary of State is an example where the directors acted appropriately in continuing to manage the company. So it is not every time the company have financial difficulties and you continue to trade, that's fraudulent trading. That's not true. You must also look into the facts and circumstances. In some situations, it may be possible. The court would say you were acting appropriately, so Section 275 will not act against you, and therefore individually, you will not be liable for the debts of the company. Okay, application. So in this case, Marco and Eliza decided for the company to continue to trade despite warnings from the company's auditor that the company may face insolvent liquidation. So that's quite serious wording from the auditor. The auditor is not just saying the company is in financial trouble. Okay, it's not just saying, there was a cash flow problem. Okay, it's actually saying it's likely the company will face insolvent liquidation. That means, number one, it's insolvent, it cannot repay the debts it's due. And number two, most likely it will be a court winding up, insolvent liquidation. So quite serious information provided by the auditors to Marco and Eliza. So what did they do? They, as directors, they knowingly continue to trade despite the auditor's warning. So already there's some risk, a risk of 275, okay? So the key question would be whether they carry on business with the intent to defraud the creditors. So did they order goods knowing that they cannot repay the creditors? If they did, much higher chance there's a risk that Section 275 will be invoked against them. So the situation here is not the same as in that case. As the auditors already advised Marco and Eliza, the company likely will face insolvent liquidation. So Marco and Eliza will need to provide evidence to defend their decisions, not to follow the auditor's advice. Otherwise, they could be in serious trouble under Section 275. Okay, so the order of distribution, we have seen this before. So you can see the secured creditors, as in the fixed charges, would have the highest priority in this list. The liquidated expenses will be next. Then you have the preferential creditors. So that's why in this story, there are still employees not paid the wages. So they are protected as preferential creditors, but only up to a maximum of 8,000 per employee. Okay, if some of those wages included payment in lieu of notice, then up to the first 2,000 per employee. And if it included any long service leave payment, then up to 8,000 per employee. Also, it mentioned in the story that the company also owes money to the tax authority, so that would also be covered here, statutory debts as a preferential creditors. So all these would have priority over any floating charges if that was granted and held to be valid. Okay, and of course, unsecured creditors, and I explained. So in Eliza's case, her loan, the 100,000, would be reclassified as a unsecured creditors because she has to repay the $100,000 back to the company. So she would sit in line basically as unsecured creditors. If there's any money left of the company's asset after settlement of all of these other items, settlement of floating charge, then it will be distributed pari passu, meaning you also need to see how many other unsecured creditors and will be paid based on the portion, the value of your debt. Okay? Okay, so I have now covered many questions from past exam papers. But as a reminder, as I mentioned at the beginning, these are really just for illustration purposes, mainly to help you with exam technique, how to tackle each question, how to work out which one are the main issues, which one are the relevant rules, apply to the facts, do some analysis to arrive at your answer. Okay, clearly, these past exam questions, they did not cover all of the topics in the syllabus for Hong Kong company law. Okay, so that's the reason why if you're revising, do not just focus on past exam papers. That's why I do not recommend candidates to just do as many past exam papers as possible, because you can see there's a limit on how many topics that they can cover. Also, as we went through many of the past exam papers, you see some topics they're examined again, they're duplicated. In that case, no matter how many times you do the past papers and repeat the same topics, I think the added value will be limited. Okay, so that's why I think definitely you would want to review the other topics as well. Okay, these are just to help you practice. But if you do decide to practice any of the past exam questions, including the ones we have gone through in this online workshop, I will still encourage you only look at the question first. Do not look at the answers in the past exam paper. Do not look at the suggested solution that I place in these presentation slides for the online workshop. At least try them yourself first. Okay? Because it's very easy to answer a question once you look at the answers already. Okay? So please, the whole point is to try to look at the question to work out what are the main issues I want to discuss. Are there one issues or two issues? Is it part A or part B? Is it two sub-issues for part A and two sub-issues for part B? Once you do that correctly, then most likely the rules you look at will be the relevant rules. Okay, the two are connected because by identifying the relevant issues, you're already narrowing down the scope out of the many topics in the syllabus for Hong Kong company law. And if you're able to explain, number one, the relevant issues at hand, and number two, the relevant rules, you're already almost halfway there. You're already almost halfway there. Then you apply those rules, those principles, and those requirements to the facts. You already finished most of the questions. Do some analysis, get your final answer. Well done. Okay? So that's the approach I would suggest for you. And that's the reason why I recommended the IREC approach. But of course, it's just a Recommendation is entirely up to you which method you use on how you answer the questions. Okay, so some reminders, okay? These reminders I would provide to you. Number one, if the exam is a handwritten exam, meaning you'll be writing your answer, then legibility is very important. Imagine the marker looking at your answer script. If the marker cannot read or understand your answer, cannot read or understand what you've written, there's no way you can get any marks. Okay? So my understanding, the best practice for marking professional exam is if they do not understand what you've written, no marks will be awarded. They will not guess what you have written. Okay? Because if they do that, it will be unfair. What if they guess incorrectly? Okay? So that's number one, legibility, very important. Now, some of you may say, I do not have beautiful handwriting. It is okay. Okay? If you write it down slowly and clearly, if you space out your work, and there are many lines on the answer script. There's no need to squeeze 20 words on each line. You can space it out 5 or 6 words per line, use more rows, and then have an empty row in between each paragraph. Yes, have separate paragraphs. Already very easy to read. Okay, so legibility is not just on how you write, but also how you structure your answer. If you have less words per row, it's not all squeezed together, easier to read. If you have paragraphs and you have empty row in between each paragraph, again, easier to read. Okay, also, if you have subheadings, much easier to follow. You will notice as I was going through each question, I have very clear headings and subheadings. Okay, I would say now I'm talking about the director's duty of one of them. Now I'm talking about unfair prejudice. Now I'm talking about the allotment of shares. Now I'm talking about the alteration articles. Can you see anyone looking at subheadings? Very easy for them to follow. Okay, so that's what I would suggest. I would also just suggest, despite the limited time, plan the structure of your answer first. That's what I would suggest. Okay? Do not just write down whatever's on your mind and then, I will talk about this, I'll go back and talk about that. It's very difficult for people to follow. But if you have a good plan, a good structure at the beginning, may only take you 30 seconds, then it's very easy for you to follow that structure. So for example, I look at a question, I notice there are 3 sub-issues. The first issue is talking about allocation of shares. The second issue is about refusal to register the transfer of shares. And the third one may be talking about, I don't know, maybe the rights to whether the director should disclose their interest in the transaction. That's 3 sub-issues. You write that down. So that's why when you answer the question, you will first answer the first sub-issue, answer the second sub-issue, answer the third sub-issue. You can leave some space in case you want to add something later. That way, when I'm the marker and I'm marking your answer, it's much easier because I will do it one sub-issue at a time rather than jumping around back and forth, very difficult for markers. Okay, so that's my suggestion. Okay, now if it is a handwritten exam, never ever use pencil. Why? Very simple. Very difficult to read. Use a pen. Dark blue, black, very professional and easy to read. And I'm guessing at the end of the day, you want the marker to be able to read your answer so the marker can give you marks for your answer. So never ever use pencil. If you use pencil, another reason, in addition to it being difficult to read, is if someone reading your answer script accidentally their hand rub across the answer, if it's a pencil, may no longer be legible. It's smudged across, cannot read. So I'm not saying the marker would deliberately do that, okay? But things can happen. And to protect yourself, definitely use a pen so that you will not have the smudging effect if you use a pencil. So very simple, okay? Another reminder, but a very important reminder, is time management. Okay, I've seen many candidates when they sit exam and they do not do well, and one of the top reason is time management. You have a limited time, but you must attempt all the required questions in order to maximize the number of marks you can get in the exam. There's only 3 hours. You don't have 1 week or 2 weeks to answer the exam question. You only have 3 hours, so it's limited time. So that's why you must allocate your time based on the marks allocated for each question or each part of the question. That's common sense. So section A, each question, short question is only worth 5 marks. But section B, each question is worth 25 marks. So for time management, you will definitely spend 3/4 of your total exam time on section B and 1/4 in section A. That's common sense. So no matter how well you answered the short question in section A, the most marks you can possibly get is 25%. And I told you in the exam, no one gets full marks. So that's why time management is important. So how can you improve your time management? Follow the advice of the examiner. Do not waste your valuable limited time on writing out the story again. In writing out the long question again, it's not necessary. Okay, so hopefully you can see in my presentation slides, for each issue, I would briefly write down the main issue. I would not repeat the long question word for word. There's no need because I have limited time. So that's why there's no need to repeat the story in the question, no need to retell the story of the court case. You notice all the court case, I focus on the principle. I do not go back to the story. Mr. Solomon, he sold shoes and he formed a company and then he became in financial trouble. I don't need to talk about that. I just talk about the separate legal entity. Once you properly form the company, the person and the company are separate legal persons. That's enough. So that's why you do not need to spend time talking about the story. The only time I mention any of the facts of the story is if it helps me explain the principle of that case. Okay? So of course, now we have looked at many past exam questions and we focus on the main issues only. It's entirely possible there may be some minor tiny issue that may also be relevant. But since you're attempting an exam with limited time, you want to maximize your return for investing your limited time by limited effort in writing your answers. That's why if you look at the question, these two are the main issue, then focus on answering them first. Do not think on some tiny little issue, that might be relevant as well. Because you have limited time, do not try to get a perfect answer. Focus on the main issue. Maybe there's 2 main issues, maybe there's 3. Answer them. I'm sure by then you already use up your time for that question. Move on to the next question. Okay, so this is all very important exam technique. Time management is important and it would make a difference. You're maximizing your return, trying to get the most marks possible based on the limited time. Okay, so now after all the reminders, what to do next? So there's still one more online workshop remaining, and that's the mock review. So that's why my suggestion, if not already done so, review the topics. Okay, I understand many of you are working as well, very busy, but at the very beginning, on part 1 of the online workshop, I already reminded, it start early. Okay, every week, which day is your study time? Is it Saturday? Is it Sunday? During the week, which nights can you also use for studying? If you can have 1 extra night per week, after 4 weeks, after 8 weeks, is many nights already, okay? So I assume you have already allocated some time for revising for this paper. So hopefully you are doing that or you have done that, review the topic. Second, of course, review the questions. There's nothing wrong to review the questions because the examiner comments are very helpful. It's telling which part have done well, which part have not done well. And you can also see the improvement over time. Some of the weaknesses or things they did not do well in the earlier papers, in the recent papers we looked at, we no longer see those comments, which is good. Okay, which means the candidates, after looking at the past exam papers and examiners' comment, they did not make the same mistake again, which is good. And then, of course, you can try to practice some questions yourself. So if you, as I mentioned before, if you have a past exam question you want to practice, it is okay. Just make sure you only look at the question. Do not look at the past exam answers. Do not look at some of my suggestions in the PowerPoint slides. Just try it yourself so that you in practice identify the relevant issues, relevant rules, apply to the story, do some analysis, you finish the question. Okay? Now, most important, I know some of you will be attempting the mock exam, which is good. Okay? But please remember, it's a mock exam, meaning it's supposed to help you prepare for the exam. So in the exam, if you only have 3 hours or 3 hours, 15 minutes to finish the paper, then when you do the mock exam, you should have a similar limited time condition. Otherwise, it's not a mock exam and it's not helping you to prepare. Okay? So that's why if you only have 3 hours or 3 hours, 15 minutes to do the exam, you should try to have around the same time for your mock exam. Okay? If possible, give yourself 3 hours to try it. That will be the best practice for you. Okay? Some candidates, they spend 2 weeks answering the mock exam like it was an assignment. I think that's not good practice because in the exam, you won't get 2 weeks. In the exam, you only get 3 hours and 15 minutes. So that's my suggestion. More importantly, of course, is for each question, give it a good try. Okay, look at the question and then try to work out what is the issues before you work out what's the relevant rules before you try to answer the question. Now, most important, of course, the mock exam is just a practice paper. Okay, the topics in the mock exam most likely will not be the same as the topics in the final exam. Okay, that's why your revision should not be the mock exam only in terms of topics coverage. When you're reviewing the topics, you need to look at them in the study materials so that you have a good understanding. So for example, in one of the past paper we looked at, the examiner examined pre-incorporation contracts. Maybe that wasn't in the past exam paper before, so some students did not revise. So the moment that was examined, they could not answer because they did not revise that particular topic. So that's why it's good to at least have a basic understanding of different topics so that if a new topic come up in an exam, in the final exam that you will be facing, at least you can answer something. Okay? It is okay. You don't need perfect marks. You don't need top marks. You only need to pass the paper. So if a topic is examined, then at least you can answer something, you can score some marks. Obviously, for section B, because you can choose which question to answer and which one not to answer, I'm thinking if it still remains the same, then if it's 3 out of 4, then you choose the one that you can answer best. So if there's one question on a topic you really do not know, but for the other 3 questions you can answer, then of course you choose the questions that you can answer best. Okay? So thank you very much for attending the online workshop, part 1 and part 2. Hopefully you find this helpful. Hope your revision goes smoothly and then you have a chance to try your mock exam. Hopefully you try it with limited exam time condition, maybe within 3 hours. And then I'll look forward to seeing you then in the final review. Thank you.